If this is your first time to the Living in New Jersey channel, or perhaps you already live in New Jersey and you're just looking for a new home to buy, today we have an important message for home buyers. Sellers too, but really it's home buyers. Stick around, we're getting after it right now. If this is your first time to the Living in New Jersey channel, please feel free to click the subscribe button, tap the bell for notifications so you can be the first one to be alerted to amazing videos like this one with awesome people like this, by the way. My name is Matthew Williamson. I'm a luxury realtor here in New Jersey, and the team and I on the daily get text, calls, we get carrier pigeons, smoke signals. People, you know how I feel about faxes. I don't deal in faxes. This is in 1852. But once again, we get communication on the daily from people just like you looking for a home, and they want to be turned into what you see around me here. What you see, those are our clients, happy clients that made it to the promised land, otherwise known as the closing table, folks. So whether you're looking to move tomorrow, which is kind of soon, or 3 months, 6 months, yeah, tomorrow, but we get it done. Either way, feel free to reach out to me. My information will be down below in the description. Today, we're gonna talk about something that we get asked a lot. I get asked this question a lot. Before we get into it, please introduce yourself.
Hi.
Hi.
My name is Gretchen Oleg. I am a partner at Phelan, Franz, Oleg & Wegbright. We are a law firm in Westfield, New Jersey. We do residential real estate closings and transactions, and it's my pleasure to be here today, Matthew. Thank you.
I am thrilled that you're here. Gretchen, by the way, is my preferred legal counsel when it comes to real estate. Pretty awesome. I'm not going to lie. That's a free endorsement, folks. I just want you to know. Pay you later. So what we're going to talk about today, look, sellers and buyers, this will be interesting. Both people would be interested here, but really a buyer, because they're the ones putting up the money, is security deposits. So in some states, it's also called good faith money.
Yep.
In a lot of states. And here in Jersey, it's security deposits. And a question that comes up when you're a buyer and you're writing an offer, and especially a first-time home buyer, right? Typically limited funds, you'll be very careful with that money you've saved up. There's a line that says, right there, what's the offer price? Offer price is, $500,000 on in security deposits. A lot of people ask, how much is a security deposit? How much should I put up front? Those are great questions, right? And that can vary from deal to deal and transaction to transaction. But the bigger question, and I think peace of mind, is buyers are like, can I lose my money? So, the main focus of this video is, can a buyer lose their security deposit if for some reason the deal gets a little squirrely that, goes a little sideways?
Not to sort of get distracted, the security deposit, the good faith deposit, is really intended initially with the offer to prove to a seller, number one, that you have the financial means to make this purchase, right? Yeah. So I'm going to put down sufficient enough money as a deposit before we even get close to the closing table to show that I'm a worthy buyer. Yeah. And then secondly, it offers some security to a seller, right? So the real question is, at what point can the seller keep my deposit?
That's a better way to put it.
So there's
more eloquent.
Clearly, if we close, the deposit that's been made will get turned over to the seller.
Yes.
The other occasion in which a seller may claim that they have a right to your security deposit is if you breach the contract. So the question is, what constitutes a breach of the contract? So essentially, when you sign a contract, the buyer's agreeing to buy based on these terms, and they reserve a couple of what we call contingencies, right? So it says, I'm going to buy your house if I can get a mortgage. That's called the mortgage contingency. And if I do an inspection and we're able, seller and buyer, to resolve all the inspection contingencies. And those are the two primary contingencies. And so if neither of those contingencies can be met, then the buyer rightfully can terminate the contract, walk away, and get their deposit back.
Fair enough.
But what if the buyer tries to walk away for some other reason?
Just change your mind?
Right.
Just they don't want the house anymore.
Right. They're up the next day, somebody's having a panic attack, and they just changed their mind. So that's not a legitimate way to terminate the real estate contract. If we're through attorney review, that deal is done and dusted.
I do feel bad about the panic attack. You do have my sympathy.
As do I.
But
and maybe the sellers will feel bad, and we can negotiate a termination.
Maybe the sellers will terminate because you, the buyer, had a panic attack.
Right.
Very highly unlikely, though.
But those are the situations in which if the buyer tries to leave the deal,
Yep.
And it's not a lawful contingency, then it can be considered a breach of contract. And in that situation, it is not likely that the sellers are going to agree to release the deposit. And it then becomes held subject to the resolution of the breach of contract claim.
And basically sits in the attorney, whether buyer or seller side, whatever was agreed upon for
Right,
that,
right.
just in an escrow trust account.
Until the parties figure it out.
Here's a question, and I have no doubt it's sort of a huge variable question. In that type of scenario, is there a legal clause or something that says, okay, if it ends up here, right, where the money's held, can it, be tied up there potentially for an eternity?
Oh, sure, absolutely. Because then you have a separate lawsuit, right? You have you have potentially a breach of contract claim that's going to be brought in civil court. You have litigators, attorneys who are now sort of fighting about what are the seller's damages. A seller has a legal obligation when the buyer has breached the contract to relist the property and try and sell it as quickly as possible. But if you agreed to buy my property for $500,000 and I had to relist it and I could only sell it for $480,000, I have damages of $20,000, right? And so those are all pieces of the pie that have to be resolved in a breach of contract claim. Could take months, could take years. It's never a good idea to breach a contract, is obvious.
Sure.
But you have to be very mindful of being appropriate in a real estate transaction so you don't sort of surrender, your rights to your deposit.
And now, what we just, before, as all the home buyers right now are just all in Jersey freaking out. Like, what the, that was what we've given you folks, to be really clear here. It's sort of worst case scenario. This is not typical. Like, oh my God, how often does that happen? In our years working together, that we've had it happen. And we've had some
We've never had an unlawful termination of a contract or a breach of contract claim, right? Because nobody, will look at what are the percentages of deals where there are breaches. Very, very slim.
Very slim to
right?
none.
And so if a buyer can't get a mortgage, they can terminate, get their full deposit back. If there are legitimate inspection issues that can't be resolved, the buyer can terminate and get their deposit back. And the majority of buyers are properly motivated and would only terminate under those scenarios.
So just, once again, call me out on any of these that are wrong, but, at least so it's said, I imagine examples where, a breach of contract would at least, that flag would start to get perked up a little bit is, like I said, panic attack, right? Change of mind, woke up and was just like maybe buyer's remorse, like don't want it anymore.
Right.
And I see this happen a lot, buyers. I know you do this, where you're in attorney review. You maybe past attorney review, whatever that is. And for some reason you're still looking at houses online. So you might think something better came along. I got to find a way out of this transaction. And if there isn't any sort of legal grounds, right? Any one of those sort of scenarios could potentially be a breach for someone to more or less what boils down to, I just changed my mind. I don't want the house anymore. Peace out. Well, when it comes to the deposit, and I definitely want to ask this, when a deal is terminated on legal grounds for both parties, there was not a meeting of the minds here. For the funds to be released, do both sides, I guess the seller and the seller attorney, the buyer attorney, does everybody's got to sign off for those funds to be released? Is that accurate?
Correct. So if I'm holding the deposits in my attorney trust account, I will not release them until the other side has agreed that there's a lawful termination. It's an ethical obligation of mine. I'm not risking my law license to release a deposit inappropriately. Yeah.
Correct. So that goes back to, once again, if someone's trying to, we want it out of the house, give us our money back. Yeah. Well, if you're starting, in that kind of bad case scenario where it's a breach of contract, if anything out of the gate, and even on a regular, even if one's getting terminated, unless everybody's signing off, the money doesn't come out of the account.
In the trust account.
Just sits in the trust account.
Yeah.
So
a non-interest bearing trust account. It's not where you want to put your money.
This is not a 401k or an investment.
Right.
It just sits in a non-interest bearing trust account and has cobwebs all over it and sits there forever. Once again, don't be afraid as far as doing security deposits, right? That can make a difference in a deal. Right? If you really want a house and you're motivated for that property, don't be afraid. No one's taking your money and stealing it. They're not going to take it away. And sort of also in layman's terms, as it were, to clear it up on this video, is people feel that security deposits are extra money, and they're not. So, just an easy example is if you are going to buy a $500,000 home in this example, and you are going to put down a total down payment. The bank says 5%. You got to put down 5% of $500,000. If I got my math right, that's like $25,000.
Right.
$25,000. You can put 10,000 of that as a security deposit up front, and when the deal goes through a transaction, that 10 that you put up front just goes back in towards your down payment.
Yep.
Right? You're basically going to bring $15,000 to closing. So it's not additional money. I want to clear that up. A security deposit, good faith money, is not additional. It is not extra. Typically, it is usually a portion of a down payment, just shifted up front to the front of the transaction to show the seller that you have skin in the game. Because the seller knows, if you're like, I really love your house, I want to make an offer on it, and here you go. And your security deposit's $1,000. No offense. If you're like, I'm leaving the contract, what do you want to breach and lose $1,000?
Right.
To be clear. So the more money you put up front typically shows a seller how serious you are. And as long as you don't have a panic attack or buyer's remorse, the money is fine. Is there anything that you need to add on this?
No, you summarized it beautifully.
I appreciate that. Once again, our information will be in the description down below. Feel free to click the subscribe button. Once again, tap the bell for notifications so you can be alerted to amazing videos like this. And once again, thanks for giving us your time. Thanks for tuning in. We'll see you around the block.